Hello, it's me again, Professor Chris Coughlin. In this module, we're going to discuss some basics of legal writing. Within your first few days of law school, you will hear that your legal writing course is the most important course you will take in law school. This rumor is, in fact, true. Legal research, analysis, and writing are tasks that most lawyers do every day. In your legal writing course, you will learn the fundamental tools of the profession, the ability to research a legal issue, analyze the law, and effectively communicate your analysis. These skills and the theory underlying them will enable you to excel in both law school and the practice of law. The credit hour phenomenon. Perhaps the most common complaint from Wendell students is that the workload required for legal writing is disproportionately heavy compared to the credit hours allocated. Students often find that their legal writing course requires far more time and energy than their 4 credit property classes. This causes some students to disregard the importance of this course. While many schools have or are considering increasing the credit hours to minimize this disparity, don't sell yourself short by focusing only on the number of credit hours awarded. Your legal writing course is the foundation for law school and the practice of law. Types of legal analysis and writing. During your 1L year, you will be focusing on 2 types of legal analysis and writing, objective and persuasive. Usually, the first semester of your 1L year is dedicated to learning objective legal analysis. Objective legal analysis and writing looks at a factual problem, considers a range of results, and then predicts which result is most likely. In doing so, you remain neutral in your analysis rather than advocating for a particular outcome. Your goal is to analyze, educate, predict, and inform. You will do this by drafting an internal law office memo from an associate, you, to a fictitious senior partner, generally your professor, analyzing the law as applied to a given set of facts. Your second semester legal writing course is dedicated to persuasive writing. Persuasive legal writing is advocacy. You are taking a position and writing on behalf of a client. Students learn persuasive writing through researching and producing a trial and/or appellate brief. In many schools, the persuasive brief assignment is not only used for your legal writing course, but also to compete for a spot on the moot court team. This is a prestigious co-curricular law school activity where students participate in simulated appellate court proceedings. You can learn more about moot court and other co-curricular activities in Chapter 24 of 1L of a Ride. Oral argument. Another unique part of the spring semester is the oral advocacy component. For many students, oral arguments are the most exciting and also the most terrifying event of the 1L year. Oral arguments are exciting because it is often the first law school exercise that will make you feel like a real lawyer. The terror aspect comes from a generalized fear of public speaking, heightened by the fact that oral arguments can amount to public interrogation. It's normal to be nervous about public speaking. Surveys show that public speaking ranks higher than death on a list of people's biggest fears. However, although public speaking and the idea of being drilled with questions from a mock court panel may sound nerve-wracking, oral arguments will be one of your most memorable experiences in law school. Success in legal writing. Success in legal writing requires a great deal of time and effort. Here are 3 tips to succeed in legal writing. 1, know your audience. 2, identify and analyze only the narrow legal issue. And 3, take sufficient time to break the assignment down into manageable phases. First, you should know your audience and his or her expectations with regard to the final work product, whether it is your legal writing professor, senior partner, judge, or client. I learned this lesson the hard way in my first year of practice. I was asked to analyze an informed consent question for a healthcare entity. I researched, analyzed, and wrote almost 40 pages of text. I sent it to the general counsel, and she called back, irate. She said that had she wanted a treatise on health law, she could have purchased it rather than pay my hourly rate. Had I focused on my audience and her expectation, I would have avoided this embarrassment. Second, you must be able to identify and write about the precise legal issue posed. To do this, you should have a comprehensive understanding of the facts of the case within the specific context of the legal question. Avoid this common mistake. Instead of focusing on answering the question asked, many students try to go beyond the facts to find alternative areas to explore solely to make a unique argument. Students who do this waste time and space for minimal to no return. While legal analysis can be an avenue for creativity, remember the old adage that when you hear hoofbeats, your first thought should be horses and not zebras. So consider all viable alternatives, but keep your analysis focused on the question at hand. While you may want to point out something other students have not considered, do so only after analyzing the most likely scenarios. Third, remember that effective legal writing is not simply about constructing sentences. It is about conveying legal analysis in written form. Effective legal writing makes complex ideas understandable. It looks simple, but takes long hours and multiple drafts. Make sure to give your assignment the time it needs. To overcome the challenges of a large workload and time constraints, the most successful students break the assignment into manageable phases. The three categories are 1, the pre-writing phase, 2, the downdraft, and 3, the editing and proofreading phase. 1, the pre-writing phase. One common mistake that students make is that they begin writing too early. You don't want to spend countless hours working on a final draft only to realize that you missed a key fact or legal issue. Utilizing pre-writing strategies such as case charting and outlining can help you avoid such pitfalls and become more efficient. Let's consider a scenario where your client was charged with a DUI after being found intoxicated but asleep in the passenger seat of his parked vehicle with the engine running. Was he driving while intoxicated? After researching this, assume you cannot find an exact fact pattern like this in your jurisdiction and need to instead pull principles from similar cases. By organizing your research in chart form, you will see themes and how the law is developing. Charting enables you to develop a more nuanced understanding of how the law might affect your fact pattern. Another strategy is to outline the structure of your arguments. This is done by laying out the charted cases, followed by the relevant portions of your case. The goal here is to establish an outline that walks step by step in broad terms to a logical conclusion. The downdraft. Using your outline, you should be able to put together a downdraft where the goal is to get some words down on paper. Placing ideas down on paper helps you to avoid writer's block. This draft is not meant to be anything more than getting your ideas out, and you should continue revising your analysis and organization until you have a draft you can be proud to attach your name to. Editing and proofreading. Make sure you leave sufficient time for editing and proofreading. This part can take as much, if not more time, than drafting the initial document. In fact, studies show that successful students spend the majority of their time editing and proofing. Your goal in this phase is to refine your work product so that it reflects clear and precise legal analysis. You create clear and precise legal analysis by working off the assumption that the reader is not familiar with the specific issues, authorities, analyses, and arguments. Clear and precise writing, free of careless mistakes, makes you more credible. In today's world, it seems like every small story gets picked up by the national blogs. You do not want to end up like the attorney who had his motion denied by a federal judge who described the motion as, quote, riddled with unprofessional grammatical and typographical errors that nearly rendered the entire motion incomprehensible, end quote. That attorney was ordered by the judge to reread the rules of civil procedure and hand-deliver a copy of the judge's edited version of the motion to the clients. As sanctions go, this was mild. It was, however, hugely embarrassing. In sum, your legal writing course should be given the utmost importance as it teaches you how to be an attorney. By learning how to effectively communicate both objectively and persuasively, there is not a legal problem you should not be able to tackle. Let's proceed to the self-assessment.